Thank you very much. I hope I will be in time. So I would like to thank you all for your presence and thank you for good talks during this stay. It is also fruitful. And today I am asking myself if contemporary system of the sources of law makes sense and if its structure is one of the cause of the rule of law crisis. In order to assess whether the legal system needs to be changed, it is necessary to identify the given problem, determine the current state of the law in the area to be regulated, and we've done it in our research, and then consider whether the problem to be solved is due to faulty legislation or other reasons. So with this in mind, it is necessary to recall the basic features of the Polish system of legal sources and confront them with the measures we have called reverse rule of law. And now I would like to make a few comments on the principles of the sources of law in Poland and connect it with these problems with the rule of law. The first one is the principle of the supremacy of the Constitution, and it means that all legal acts must be in accordance with the Constitution, which determines the order of sources of law in the framework of actions for the public authorities. And it is also explained in the Constitutional Tribunal case law, even the case law on European integration. Today, although the word constitution is mentioned in various contexts, one may have doubts about ensuring its supremacy. Moreover, more and more often, the phrase rule of law appears instead of the Constitution. And those who justify actions outside the law by restoring the rule of law do not remember that the rule of law is derived from the Constitution, and it is the basis of the rule of law. The Constitution states that the authorities act on the basis and within the limits of law. Yesterday, Professor Rafał said it also about legalism. And the law is also the Constitution, while actions are being taken in disregard of the constitutional rules of the sources of law and the principles of lawmaking. And in this context, the question arises as to whether the principle of supremacy of the Constitution is tenable in the current legal situation, where many actors influence the formation of the legal situation in the state. In 2005, in the ruling on the accession treaty, Constitutional Tribunal said that Poland would remain bound by international obligation as long as it could act as a sovereign and democratic state. And in 2021, the same Constitutional Tribunal found that the norms derived from EU treaties in practice of the European Court of Justice have passed this critical point, and this is the limit of the integration. So we have here this line of jurisprudence of Constitutional Tribunal. The second principle of the sources of law is the dichotomy of the sources of law, and the sources are divided into universally binding and internally binding law. It is important in the perspective on the actions of Polish government, because according to the Constitution, this divisions means that every normative act must fall into one of these two categories. Generally, applicable law applies to all who are under the authority of the Republic of Poland, and it can be a source of orders, prohibitions, powers, and duties. And internal law is addressed to organizational units subordinate to the body issuing the act. This means that an internal act cannot in any way affect the legal situation of entities that do not belong to given organizational structure. And now it seems that the constitutional distinction between general binding law and internally binding law is losing its significance, and the authority freely uses internal acts to regulate external situations. For example, resolutions of Sejm concerning National Council of Judiciary, Constitutional Tribunal, Polish Television, as well as resolutions of Council of Ministers concerning non-publication the judgments of Constitutional Tribunal in official journals. And the purpose of these acts is to produce a certain effect. For example, the general prosecutor and the ombudsman refer to this resolution, internal resolution, when they refuse to participate in the cases before Constitutional Tribunal. So here we have a violation of the dichotomy of sources of act. Another principle is the hierarchy of the sources of law, and it means that each normative act has its own rank in the hierarchy. And how is the hierarchy of sources of law violated? Lower ranking acts and internal laws are used to change laws and constitution. Governmental legislation tries to change this parliamentary acts and even constitution. For example, the structure of judiciary, composition of the Constitutional Tribunal, and very often the laws are, there are laws that directly contradict the Constitution. And the example of it is the law on the Constitutional Tribunal, which abolishes the effects of the judgments of the Constitutional Court, the effects of which arise from Constitution, direct from Constitution. So we have this problem with hierarchy of the sources of law. So, and next thing which is important, it is the closed catalogue of the sources of law. In Polish constitution, we have this principle that the only organs listed in constitution may create universally binding law, and all types of universally binding law are listed in the constitution. This means that neither the circle of authorized subjects nor the types of universally binding legal acts may be extended by subconstitutional acts. So we can't create new universal binding acts via parliamentary acts. Public authorities use various types public authorities use various types of legal acts, such communication, guidelines, opinions, which are neither sources of universally binding law nor sources of initially binding law, but which are issued in order to achieve certain legal effect for everyone in the territory of Poland. An example of this is the interpretation of the introductory provisions of Act on the Public Prosecutor's Office, and the recognition, contrary to the construction of this provision, that the provision on the return of public prosecutors from the retirement was episodic, whereas structurally it did not have such character, nor did any of the interpretation give it such meaning. The norm in question was deducted on the basis of commissioned expert opinion. So here the expert opinion became a source of law. And another important set of principles concerns the substatutory acts. In Polish Constitution, any substatutory act must be based on the statutory authorization and must be consistent with the statute and the Constitution. In case of the regulation, the authorization must be specified and not blanket, and regulations are used to be disregarded of statutory authorization or in violation of the law. And here we have an example of the regulations of the Minister of Education on the teaching of religious education. The law on education system clearly indicated the requirement to obtain an agreement, not just opinion, from churches and other religious associations to enact this kind of act. And minister enacted without this approval, without this agreement. So we have clear here violation of the Constitution. And we can ask what is the reason for mentioned irregularities. Drafting the Constitution, the creators of the Constitution of 1997, wishing to prevent abuses within the framework of the sources of law, such those that occurred in the early 90s. Then, in early 90s, Council of Ministers issued independent resolutions encouraging on matters reserved for Parliament. And now we come back to this. The creators of the Constitution proposed a separate chapter on the sources of law in Constitution and made it more rigid, which left many issues unresolved and created a lack of competence in the shaping of basic legislation. Each substatutory act was closely linked to the act, which in case of regulations made administrative legislation more rigid. Today, a regulation may be issued by a specified body in Constitution on the basis of detailed statutory authorization, which includes the body issuing act, the scope of matters transferred to be regulated, and the guidelines regarding in content. Therefore, in practice, the Council of Ministers has not flexibility in creating law, which in the past led to exceeding powers and issuing acts outside the authorization, and today the same is done. Okay. This inconvenience in managing the state was visible during pandemic, when the government had difficulties after issuing regulations that were supposed to protect against the pandemic. And this formalization led to a situation where ministers began to use announcements, which are in fact normative in nature, or at least serve to reconstruct legal norms, and it affects the legal system. The example of it is the list of journals mentioned by minister announcements, but it creates norms, for example, in evaluation of higher education or for academic degrees. Another problem is lack of chapter in Constitution on the EU membership in Poland and exact relationship between EU law and Polish law. We have also dispersion of legislation into various legislative centers without clear indication of the relation between individual system and sources of law. There is a relativization of law and abandoning its formal application. As it was said, the law is what we say that is law, not what Constitution said is the law. And the most important, in my opinion, there is a lack of legal culture and insufficient legal education related to shaping attitudes of respect for the state and the law. And of course, the fight of political fraction regardless of the legal rules established in the Constitution. So let us turn to the question of whether the current system of sources of law in Poland makes sense. Today, in Poland, we have this authoritative this model of creation of law. It is done in the constitution, and this social creation of law is an auxiliary nature, and it is not that decisive for final legislative decision. There are opinions and so on, but the final word is to the parliament or to the government. And for this reason, despite the problems, we are bound by acts of statutory law, and we have observed and applied them until the presumption of their constitutionality is overturned. This rule of law, this is set of the sources of law, makes sense. Of course, it need to be a little bit amended, but if we make it more flexibility, the erosion of the rule of law will be deeper. Thank you very much.